Hi, folks. Next up on This Week in Law, we've got antitrust in the form of Apple, AT&T, and T-Mobile. Is the Google book search settlement finally dead? We don't know. We're going to find out, though. Evan Brown is here, as is from Gigalaw, Doug Isenberg, and Alessandro Daliana from TWiL. We're going to talk about whether piracy is dead. We're going to talk about all sorts of stuff. It's been a very busy week in technology law. Join us next on TWiL.
Netcasts you love.
From people you trust.
This is TWiT.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell. Episode 104, recorded March 25, 2011. Gettin' cozy with it. This episode of This Week in Law is brought to you by Carbonite Pro, online backup for your law office. Carbonite Pro backs up your files automatically and continuously so you're always protected. Learn more and try it free at carbonitepro.com. And by Squarespace. Squarespace.com is the fast and easy way to publish a high-quality website or blog. For a free 14-day trial, go to squarespace.com. Hey there, you've made it back for This Week in Law, episode 104. I'm Denise Howell, and we're here this week with an amazing array of stuff that has happened in the world of technology law and an amazing panel of folks to try and unpack it all for us. With us, we've got the Ariana Huffington of the world of legal technology, namely Doug Isenberg of Gigalaw. Hello, Doug.
Hi, Denise. Now that's a first. Thank you, I think.
Thank you, I think. Yes, we're just wondering when you're going to be acquired by AOL, so be sure and clue us in when that begins to happen.
Well, I've never refused their call.
That's good to know. Doug, of course, runs the wonderful news aggregation site called gigalaw.com, but it reminds me of Huffington Post because it has wonderful original commentary as well, and just great content altogether. And Doug's sort of an icon in our world of tech law news, so great to have you back on the show.
Thank you.
Also joining us, the founder and CEO of a company we recently featured as a resource of the week on TWiL. It is called TWiL, and he is Alessandro Daliana. Hello, Alessandro.
Hi. Thank you for being here. Yep.
It's great to have you. I'm really interested in your company and what you're doing. In case you missed our episode where we featured TWiL, it is an online crowdsourced dispute resolution service. And I guess if people were using your service or more like it, Alessandro, we would have not much more to talk about here on TWiL. So we're happy you exist, but at the same time, I guess you're cannibalizing lots of people's businesses, and we can talk about that in a little while. But first, I'd also like to welcome back to the show Evan Brown of InternetCases.com. Hello, Evan.
Hey, how's it going, Denise? Happy Friday to you. It's awesome to be here. Looking forward to our conversation. I
know, me too. Great to have you back.
Thanks.
And great to have our representative of Chicago, Illinois. Doug, aren't you somewhere in those environments too?
Well, I suppose everything's relative, but no, I'm in Atlanta.
You're in Atlanta. No, that's not relative at all. I was just kidding.
You know, they're both flyover states. So you folks in California and New York, what's it matter? You know,
we're only one time zone apart, right?
I think so.
I'm just so used to our having guests on the show, and one of them being just down the block from Evan over in Chicago, in one way or another. We seem to have a lot of Chicago guests on the show, but no, I just.
Well, yes. Considering the Atlanta traffic, I may be able to make it to Chicago more quickly sometimes than I can make it across town here.
Right. Well, we've got the U.S. well covered then, because Alessandro is in New York. So
yep,
got quite a few quadrants represented. And going on this week, it's hard to know where to start. A lot of antitrust-related stuff, so why don't we start with one of those? There are a lot of antitrust concerns about Apple internationally these days. One of them is a case that's been pending in California for quite some time. believe, the mid 2000s, even earlier than that, Real Networks was complaining about the fact that they would like for iTunes Store music to be able to play on their products. And Apple kept updating the software such that could not happen. Ironically enough, with something that they called fair play. So this case, this antitrust case, has been going on for quite some time. It's a class action antitrust case against Apple by private consumers, not by the government. And the judge in that case has decided that Steve Jobs has unique, non-repetitive, first-hand knowledge about Apple's software updates in October 2004 that rendered the Real Network's digital music files once again inoperable with iPods. And he thinks that despite Steve Jobs' health problems or anything else, he should submit to a deposition for 2 hours in this case, which just kind of blows me away as someone who has litigated before. It's a pretty rare and unusual thing to get someone of Steve Jobs' position and stature and health to be in that situation. So I'm wondering, alternately, it could wind up being something that's very perfunctory and brief and in and out. Or on the other end of the spectrum, it could be like one of those scenes from the movie The Social Network where, all kinds of fireworks are going off in the deposition. Evan, what do you think is going to happen here?
Well, I imagine that they'll try to be reasonable and use that 2 hours efficiently. And to do that, the lawyers who plan on taking Jobs' deposition will be very well prepared. There may even be some communications beforehand about, real specifics about what the questions are going to be like. In a deposition room, 2 hours flies by like that. And so if there's going to be anything accomplished of substance, the lawyers wanting to take his deposition will want to make sure that they don't have to get into any silliness or shenanigans, when all of this is actually happening. But you make a great point, Denise, when you say this is really mind-boggling that the judge is even permitting this deposition to occur in the first place, because the battle over whether you can get the CEOs or other, C-suite executives' depositions in litigation is a battle that you hear about and is fought in companies of all sizes, even, small, closely held family operations. The CEO still, a lot of this, I think, is in the mind of the CEO, really tries to be distant above the fray in the types of issues that usually are being litigated. So there's, it's very frequent that there is a battle over whether or not, the party seeking discovery will get the deposition of the big guy or the old guy in the corner office or however you want to characterize it. So I suppose that we could try to read the tea leaves and we've got to be careful in doing this too far, but we could imagine that the judge sees some real importance in the actual claims being brought here, bringing Steve Jobs in for this for this deposition like this. So it's interesting.
Yeah, I think it's fascinating. It is kind of just a sideshow to the overall question of antitrust allegations against Apple, which seem to be coming on all fronts these days and are sort of a logical consequence of the way Apple does business. They like to keep tight control over things so that things work well. But some of the assertions against Apple lately have been that their controls have nothing to do with whether something works well, but have lots more to do with Apple making money, such as their arrangements with people selling subscription services through the App Store. Doug, do you think any of these antitrust concerns against Apple are going to stick at some point?
Well, I don't know as much about the substantive matters of the antitrust law as I do some of the procedural maneuvering here that Evan was referring to, and it certainly is I agree, a bit surprising that this apparently is going to go forward, although until the deposition actually occurs, who knows? But the comments about Steve Jobs' health are interesting, but apparently, he's healthy enough to, have dinner recently with the President of the United States. Obviously, a difficult invitation to turn down, but there were photos released of Steve Jobs at a technology dinner with other CEOs and President Obama. He was healthy enough, obviously, very recently to prepare for and come on stage to introduce to the world the iPad 2, which he was successful at introducing, given the 15 million or so, however many devices have been sold of the iPads and the million plus of the iPad 2. So his health, seems to be a little bit of a side issue here. I'm not questioning his health or the legitimacy of these issues, but I've not heard any reason why it would prohibit him from being deposed for 2 hours. What's, I think, more interesting is what will Steve Jobs actually be like under deposition. I'm reminded of the deposition, I believe, of Bill Gates from a number of years ago during some Microsoft antitrust litigation. And it's sort of hard to forget, but it wasn't that many years ago, and he was not apparently a very successful witness. And how Steve Jobs will perform, we know he does great when he's on stage, but how will he do at the conference room table remains to be seen.
Well, I'm sure he's got fine counsel and good help, but he's also got an incredibly strong personality, and I guess this is one of those costs that you must pay if you're going to opt to help launch your company's latest and greatest new product. If he can go on and razzle dazzle with the iPad 2, then, as you say, Doug, a deposition for a couple of hours shouldn't be that taxing. Although I'd be surprised if the lawyers just sort of happily accept this. I could see them trying to put a bunch of conditions on it and try and make it as smooth and comfortable for Mr. Jobs as possible, which I hope that they actually do.
And I don't mean to belittle the deposition process. It's not a chair that I would want to be in, and it's quite different, obviously, than performing according to a script, because he doesn't know all the questions that will be asked, and the short answers that apparently he's accustomed to giving, if you believe some of the technology blogs, when he's asked questions by consumers via email about what's going on with some of the products, the antenna gate issue on the iPhone 4, for example, from last summer, and he sort of dashes off these quick couple of word responses. That won't probably work in the deposition. So it will be a different territory for him.
I know, Evan, can't you just see him walking in and not taking a seat, but instead just sort of pacing the room with a clicker in his hand and a screen at one end of the conference room and trying to give his keynote presentation of all the bullet points he wants to make that day?
Yeah, that's great. It might take some lawyering to get him to settle down a little bit, but that reminds me. Maybe he won't even actually be in the same room as those deposing him. It's not uncommon to take depositions by telephone or video conference or something like that. So if you're scheduling on his behalf, maybe he ought to be present in some auditorium somewhere, more on his home turf.
That's right. At one infinite loop somewhere. Alessandro, I don't know. I'm guessing you are from Europe originally. Is that correct?
No, Brooklyn.
Brooklyn. There we go. So you're just
born
have
and
a
raised
very
in Brooklyn.
Italian name.
Yes,
all right.
well,
so
that happens.
My attempt to get sort of an EU perspective from you on Apple antitrust issues is probably going to fall flat. But what do you think about Apple getting barraged on so many sides by these questions, whether it relates to the music store or their software or their hardware or their app store? It seems like there are some very long, hard looks going on to their practices.
That's par for the course. litigation is very good for business because while things are being litigated, you can develop market share. You can penetrate that market very well. And to be perfectly honest with you, in Europe and probably even in the United States to a large extent, using litigation, changing standards, lobbying in general is actually part of doing business. You know, Steve Jobs and Apple Computer are going to be able to penetrate that market, whether it be the iTunes, the iPad, develop market share, and then maybe 15 years, 20 years down the road, if it was Europe, it would even be 50 years down the road. When the litigation was resolved, they'd have the market share, they get slapped on the wrist, they will have made lots of money for their shareholders, and whoever is litigating against them, well, they don't have anything. They don't have a business anymore.
Right. Evan, do you think Apple's strategy here, or I don't know if it's so much a strategy as a mode of doing business, just sort of the way things are with Apple, do you think that they are more of a sort of ask permission later kind of approach on these antitrust issues, or do you feel that, or do you think that they feel they are on solid legal footing?
It could be a little bit of both, and it's probably that cavalier attitude that we like so much, or that's one of the things that makes us like Apple so much. We may even love to hate it to a certain extent. Mm-hmm. You know, this particular lawsuit that we're talking about here, and I think you said this in introducing the issue, goes all the way back to 2004. You know, stuff that Apple was doing in allegedly not playing fairly with real networks, and with the DRM stuff going on there. So it's easy for us to look back now, 7 years later almost, gosh, it's hard to believe, to 2004 and think, well, this was all just some kind of strategy, and there was this evil plan to take over the market, antitrust issues, notwithstanding, or be damned, and so I think it's probably just a basic middle of the, well, I won't say middle of the road, but a very basic aggressive business stance with a principled analysis of what's going on, realizing that a lot of the questions are going to be untried, particularly when it comes to the antitrust laws and how they would apply to the distribution of digital media. It's still really unclear to us how exactly the whole framework should look when it comes to the distribution of digital goods. I'll characterize it that way. In 2011, it's difficult to do that. In 2004, it was even more forward-looking, and who knows what's going to happen here. So they have the resources, they had the vision, they had the products to support it. By 2004, the iPod was already 3 years old. So, it just makes sense that they would act in this way, and there may not be too much to be gained by kind of doing psychoanalysis on them 7 years later.
Did you see Professor Goldman got some ink in the Wall Street Journal on these points, specifically with respect to the App Store issue and subscription services? Apple's plan to, or dictate, I guess it is really, that companies cannot link out or offer subscriptions other than through the application itself, and when they do so, they must pay 30% of what they make from that to Apple. Apple's got, I think, a couple of things going for it on that issue and on the other issues too. And that is that they can always, in order to make antitrust allegations stick, you have to be so heavily dominant in the market that you really are squashing other competition. And I think that that's hard to say about Apple on a lot of these fronts. On the music front, who knows? I mean, I've read that they have more of a share of the overall music market than someone like Walmart in the U.S. And we're not just talking about online music sales here. And on the online front, 70% or more. So they're certainly a dominant player. But when you're talking about selling applications or subscriptions. I think Apple's in a good spot to say, look, nobody's making you be on our platform. There are lots of other platforms out there where you can do exactly what you'd like. But if you want to play over here in our sandbox, this is what you're going to have to pay us to do it. Doug, do you think that I'm just sort of being naive about this, that, Apple's crushing the tablet and app market so that it's not really a fair choice to tell people to go elsewhere?
Well, I would never call you naive, Denise. You'd be happy to know. But I think the analogies back to what happened in the browser wars are really fascinating, because that was a time when there was really one browser, or at least one significant browser, and that was the Netscape Navigator browser. And then along comes a company called Microsoft and creates this new internet browser and decides to bundle it into the Windows operating system, and suddenly becomes the dominant player. And today, where are we after all of that litigation? I've got 3 or 4 browsers installed on any PC I'm using at any time, and kind of play around with different ones. I think we've seen new versions introduced just in recent days from 3 of the top players, Google, Microsoft, and Mozilla Firefox. And there are others. The Opera browser gets incredible reviews. So a great deal of competition, and you're right. I've heard the same figures about music sales and how much of the market Apple has, but obviously that was not always the case, and there are alternative, believe it or not, there are alternative digital music players other than those that run the iPod or iPhone, the iOS operating system. I'm a little pressed to think of anybody who actually owns one, and I think Microsoft has announced they're discontinuing their Zune hardware, so they're pretty much giving up that battle, at least on the hardware front. But there are plenty of choices to be had, and now that I think about it, I think I do know of some folks who listen to music in different ways, and they're called mom and dad. But so it's kind of interesting. I'm trying to draw an analogy that today we have a significant number of browsers out there. They're all, a lot of them are great products. A lot of us alternate among using them, and so the competition that has been created, I think, is good. What will happen in the digital music arena or smartphone app arena perhaps remains to be seen. What actually goes on with Apple and its App Store, or some of the other app stores that I know are struggling to make their presence known as well.
Well, and I think, it eats into Apple's business, but on these antitrust issues, Apple must be applauding wildly for services like Pandora and all the other online streaming music alternatives that are available today that are really just a completely different business model than iTunes, or than iTunes has traditionally been. Of course, they're going to have to respond to this. But, I think Apple's in a pretty good, scrappy place to be able to fight off all this antitrust scrutiny. I don't know if I can say that about AT&T, however. We have, of course, another huge antitrust-related story this week, AT&T's decision to buy T-Mobile for $39 billion. And, of course, the Department of Justice is examining that even as we speak to see if they're going to let it go forward. Evan, any thoughts about this one?
Just thinking about not switching from T-Mobile, thinking I might be able to use an iPhone on the network. That was my big my initial reaction. No, I don't know. I mean, this is I'm not an antitrust lawyer, and so I only think of these things really as an outsider, just like to the same extent, really, if I was not a lawyer at all. So knowing what I know about antitrust law and looking at the the threshold that must be met for there to be some violation of the antitrust laws, it doesn't frighten me too much that this is going on, because of the viability and the market share that companies like Verizon and Sprint have. They are still very I don't know how the market actually breaks out, but just watching television and seeing ads, I know that their market share must be really significant. So it doesn't seem to me that we're at a point where there should be any big concerns between T-Mobile and AT&T and T-Mobile coming together, and especially if they can do it justifiably for business reasons, like coverage and the quality of the network, making an argument in favor of the public interest, which no doubt they would be doing when taken to task by the Department of Justice on this merger here. So it doesn't make me all that afraid, just having heard it. I think there's plenty of good to be had from it, but my perspective is a little bit limited on that, and so I'm just guessing at a lot of things on this.
Well, excuse me, could I interject something there? How do you feel about the fact that T-Mobile and AT&T are the only GSM operators, whereas Verizon and Sprint being much smaller than any of the previous three, use a different system called CMDA. If
CDMA.
CDMA, thank you. If AT&T and T-Mobile merge, that means that anybody who visits the United States from abroad will be paying roaming charges to only AT&T. That gives them quite a lot of extra money, extra business that Verizon cannot get, and neither can Sprint.
Yep, that's a really interesting point. Over in the chat, Reverb Mike, who has a great chat handle, has been wondering if we've got another Ma Bell breakup in our future. I'm wondering if there are, this happened so long ago now, there are people probably in our audience who don't even remember that a long time ago they did have to break up the telephone company because it got too big. And with AT&T and Singular and now T-Mobile, we certainly seem to be headed that direction again. Doug, what do you think about Reverb Mike's question?
Well, I would say, as Evan did, I'm also not an antitrust attorney, although I am an attorney. But I tend to look at these things probably more from a consumer's perspective as well. And, I think that it certainly is a bit concerning, the consolidation of these players and fewer choices of cell phone service providers. An initial concern is, well, what will that do to my monthly cell phone bill? And obviously, we don't yet know. With respect to the issue of the difference in networks between the CDMA and the GSM and what's available in the United States and what's available in Europe, Alessandro's question is an interesting one, although, I used to face a similar conundrum when I would go to Europe from the United States with my Verizon phone and essentially have to turn it off until I returned home. So it's a fascinating question, and I will certainly look forward to seeing how it plays out. But I think it's much too early to say ultimately what this will do for the market. What it will do for the network, what it will do for the variety of products, what it will do for the cell phone bills that we all pay as consumers.
Right, and it's Silverback in IRC this time, who I think has figured out the whole 2012 Mayan prophecy, end of the world prophecy, and that is that AT&T and Apple merge, and then we have Skynet. So, end of story. What it does seem to come down to, and again, none of us on the show today are antitrust lawyers, and they are a very specialized niche of folks who have very specialized economic backgrounds and insights and a strong policy slant. But if you believe Roger Cheng in the Wall Street Journal and the folks at the Justice Department, the issue that this may well turn on is the extent to which there is competition in the local markets for your cellular wireless provider options. Alessandro, since all of this scrutiny seems to turn on how much competition there is for your wireless service dollar in the local markets. Are you seeing in New York a whole lot of competition, a whole lot of options out there for you if you were to go and want to find a wireless carrier who was not T-Mobile, Sprint, Verizon, or AT&T?
I think, well, there's Metro PCS, there's Boost. Those are the two major ones. I think there may be some other ones, but there is a market for, I think it's called MVNO, basically companies that buy bandwidth from the major operators. And a number of them have sprouted up as small companies, like Cricket, for example, in the West Coast, I think is pretty big. But Boost and Metro PCS, both of them use the old Nextel system that Sprint bought, which of course has been upgraded. So you're not really talking about real competition. You're talking about segments of the competitive segments, niche markets that exist within the larger market. The fact that you have a merger with AT&T and T-Mobile is going to create a company that I think has like 142 million subscribers, as opposed to like 136 million from Verizon. And the next competitor, which would be Sprint, I think has like 40 million. So you basically have two very big concentrations of technology with two different technologies. So how do you develop more competition? How do you develop better products and services? Because we all know that the price of the cell phone service is not going down. Never has gone down.
Right.
I think that's the major issue.
Okay, well, if nobody has any further thoughts on AT&T and T-Mobile, Doug, anything more you want to add to this?
No further thoughts other than, what's I think fascinating to see is the changes that are going on in the cell phone marketplace as well. When Alessandro said nobody's seeing their bills go down, the voice portion of my bill, and I think a lot of people's bills are going down, it's the data portion that's going up. So how we use the networks is certainly changing, and to be able to use them for the heavy demands that we're putting on them certainly requires an investment in new technology. So for what that's worth, that's my parting thought on that topic.
Evan, what do you think about consolidation potentially between the folks who provide our wired internet access and our wireless internet access, following up on that point? If the voice piece is falling by the wayside, doesn't it make sense that someone like Time Warner become a wireless carrier?
I think so. And
aren't they already a wireless carrier?
Well, I can get Comcast wireless service for my laptop here in Atlanta.
Right.
Well, they have the wireless that they use from Clearwire, which was trying to work with Sprint at one point. And at least that's offered here in the New York market.
Right. And I guess Sprint's,
right.
What was that called? Fios, has that been phased out? Because there was some market overlap there. What were you going to say, Denise? You were going to say something?
Verizon is Fios. Fios is Verizon.
Fios.
Right. I don't know. We had the hypothesis that Apple and AT&T were going to merge. Maybe that Skynet would be up against the more traditional landline carriers deciding that voice is irrelevant and offering some kind of service where you could have communication through internet telephony like we're using now as your primary mode. So who knows? All kinds of options out there. But before, what I want to get to in a moment is Alessandro's very interesting option for dispute resolution, which circumvents the courts and leverages the power of the crowd. But before we get to that, I want to thank our sponsor, Carbonite Pro. Of course, a computer disaster is devastating in any context, but imagine you are, as three of us are on the show today, a lawyer, and your client files and billing records are what's at stake if something goes wrong with your computer. More and more law offices are using Carbonite Pro online backup. I know I use it for my own practice. With Carbonite Pro, your files are backed up automatically, so it really gets done continuously. They're stored securely and safely off-site. What I mean by continuously is as soon as there is an update, your system recognizes that, and the changed file is backed up to the cloud so that you constantly are keeping track of the new additions to your data. Plus, each employee can access their backed up files from any computer or on their smartphone with a free app. Prices start at just $10 a month, so start your free 1-month trial at carbonitepro.com. You won't regret it. It's a wonderful service. For you guys who haven't tried it yet, please do check out carbonitepro.com. So let's check out something that's very innovative in the legal arena and talk for a moment with Alessandro about online crowdsourced dispute resolution. Alessandro has founded a site called TWiL that does just that. And what you can do, it's free. If you have a dispute, and so often I have people come to me where they do have a dispute with someone and it's a legitimate dispute. It's the kind of thing where otherwise you would have to go to court to work it out. But it maybe just doesn't involve the dollars to justify that. I've been reading about something called costs, an economic concept from a famous economist whose last name was Coase, C-O-A-S-E, in Cory Doctorow's book For the Win. Everything I learned about economics, I learned from Cory Doctorow, in other words. And a cost is when sort of the pain point of doing something is so strong that you do something else instead. So the example he uses is, it's good fun to go to the movies with all of your friends, but in olden times before we were all connected up wirelessly with Foursquare and cell phones and texts, etc., if you had to round up all your friends by conventionally calling them on the telephone and trying to coordinate a movie date, the cost of doing that was so high to you that you might just stay home and watch whatever was on TV instead. It had a high
cost. Was that before or after voicemail?
Well, he did posit that you could leave a message for the person you were trying to reach, but, I'm visiting someone's mom taking a note.
Yeah, geez.
Yes. So the costs of litigation are very, very high and don't really see any sign of coming down through technology. But Alessandro has this technological alternative to the legal process as a whole. And of course, there are all kinds of mediation and alternative dispute resolutions out there that don't happen online, but yours does happen online. So why don't you tell us a little bit about that and what kind of traction you're getting with this solution to letting the crowd decide people's legal disputes?
All right. Well, first of all, I'd have to say that it's not really crowdsourced because we do limit it to a panel of 5 jurors or neutrals. So,
but don't you draw those? You draw those people, though, from the broad online audience. You take volunteers from people who just come along to your site, correct?
Well, for the moment, we've limited it to a jury pool of 20 people who are registered users. And from those 20 people, the ones who accept to participate are then interviewed, like you would in any courtroom, by the litigants. And they have to agree on 5. So it does keep it at a manageable size of people.
But there's no requirement that these people have a legal background or be lawyers or judges, correct?
No, the people who are the people who go and do jury duty are people who are like you and not like you and me, but your average Joe. Although there are lawyers who do jury duty, which is true, but. So, everybody here in New York, actually, I had the first opportunity to go and sit in for a couple of days while waiting to be chosen to be a juror on during jury duty here in New York. And I was very surprised to see that there were people from all walks of life. People who were immigrants, people who spoke English, they didn't speak English. It's part of their civic duty. But that's here in the U.S. The minute you go outside of the U.S., most people don't have this opportunity. And aside from what they see on TV, but people who live outside of the U.S. have written to me and say, we really want to do this because we don't get to do this where we're from. So there's an aspect for them that's interesting.
So are you getting people signing up and resolving their disputes with the site?
Well, we haven't been able to do any dispute resolution to date on purpose because we needed to develop a jury pool that was sufficiently large. We added a bit of complexity to this in the sense that we limited it to, the jury pool selection is done with users from any country aside from the country that the two litigants are from. So if you have an American person and a French person, the 20 members of the jury pool will not be from the U.S. or from France. This has required us to wait a bit before we actually launch the service until we have enough countries or users from countries that are represented that goes at least until 20. At the present moment, that's what we have. So now we're ready to move forward.
Well, that's great. You'll have to keep us posted and let us know when your first dispute has been successfully resolved, because I think it's a really interesting model. I can think of a lot of contexts where people would want to avoid the court system and go ahead and let a jury of their international peers take over and have the final say. Evan, what do you think about this?
I've said this before. Services like this, I think, can play a valuable role in the legal industry. There are plenty of informational sites about the law. There are plenty of sites that actually let you do a little bit DIY stuff with the law, with LegalZoom and Trademarkia and, other sites, within the general genre of kind of self-serve legal assistance. And those are similar to what I see from TWiL in as much as and this is the buzzword that we toss around a lot and that we see to describe this, and others have described this as disintermediation, kind of taking out the middle person, if you will, the lawyers, taking out the courts as well, and making the process a bit more direct between those who are in need of the ultimate outcome and the means for providing that outcome. So there's an important place in the legal industry for services like this. I don't think that they will become a panacea for a number of reasons, the most important of which is related to the level of sophistication of the actual issues that need to be adjudicated. And usually the more sophisticated a matter is, the more that's actually at stake. And I think the normal human impulse would be that you don't want to rely on something as capricious as a jury pool selected from the world at large that may or may not reflect kind of a broader perspective on the world. So I look at this, and I certainly don't mean to be diminutive of TWiL, because, like I've said for the third time now, I think it can serve an important part of the legal industry. But I look at it almost in the same way as people probably looked at taking their disputes in front of Judge Wapner, in the People's Court.
Right.
Almost as if you're just doing it for sport and you really don't care about the outcome, and the outcome is not going to be critical to, your future or your familial relationships, or whether you're going to be reimbursed for that serious injury that you got because of someone's negligence, or whether you're going to be able to license, this intellectual property, these very important issues. But, for little things like, maybe a, dispute over, you sell something and the guy doesn't pay and he owes you $50. Those would be good kind of things like this. And then when that Coasey point is low because of the, what's really at stake here. So that's my take on it.
Well, if I can add a couple of things, first of all, TWiL did start off on the basis of online commerce. So generally speaking, you're talking about small amounts of money. The highest that we've been able to estimate as a part of the target market are online services like Guru, Odesk, Elance, where you have contractors that are at a distance. And you're talking about an average billing of about $4,500, which is why we set our limit at $9,000. Having said as much, TWiL is extrajudicial. So it doesn't want to get involved with the law. It doesn't want to it doesn't want the users, whether they be the litigants or the users who are the jurors, to have to be preoccupied about one jurisdiction as opposed to another jurisdiction's law or the interpretation of the law. It's just good common sense and what people consider to be reasonable. I know from my own experience that, direct and indirect, that in many cases you can go to court and you actually end up with a ruling, in the cases that I'm familiar with, a judge's ruling, that's really not reasonable at all. And to the point where in some cases, even the facts have been distorted because this is going to probably get a little bit off the point, but, in the U.S. or in the Anglo-Saxon system, we have a procedure that's called evidence. It doesn't exist elsewhere, sorry to say. Mm-hmm. And, when you have a judge who's deciding whether or not he's going to admit or not admit a piece of evidence, he's already tainted because he's looked at that evidence in making his decision. So even if the law says that such and such piece of evidence is not admissible, well, he's going to, because he's looked at it, he's going to be influenced by it.
Right.
So
your system, if I can jump in, posits that people can come in, tell their story. There are no sort of rules or parameters on that. They're evaluated for their own credibility, and what prevails is this sort of international consensus of right and wrong of how the dispute should come out. Have I summed that up?
What's reasonable? Let's put it this way.
Mm-hmm.
As far as the procedures are concerned, we included certain procedures that we thought were appropriate.
Mm-hmm.
You can come, you can file arguments, you can upload PDF files with evidence, with testimonies.
Mm-hmm.
But in the forum section, we did create a section in which people can talk about the different procedures and what they would like to see in terms of the future evolution. And to be perfectly honest, the only subject that we included, or that I included, was evidence. Because to me, that's very fundamental in the whole process. And, America's exported everything, hasn't exported its legal system. But yet, everybody comes to do business in America because of the legal system. So, TWiL, in a way, just exports that process.
Exporting it back out.
Yeah.
I like it. Well, I like any sort of new approach or new way of thinking about making disputes go away for people in a more efficient way, and appreciate your efforts, and we'll watch closely
Denise, this is Doug.
as you guys continue to... Sure.
If I could just jump in as well and say that I'm an advocate, certainly, of any type of alternative dispute resolution under the right circumstances. And as a disclaimer of that, I guess I should say that I am an international arbitrator of sorts as a domain name panelist for WIPO, the World Intellectual Property Organization in Geneva, and the Czech Arbitration Court in Prague, which are two of the arbitration providers for what's called the UDRP, the Uniform Domain Name Dispute Resolution Policy, which has, over the past 11 years now, become the primary and preferred method of resolving competing claims to domain names. And in many cases, the value of a domain name it can be significantly higher, not just what the registration fee is, but the value to the party who's using it can be significantly higher than this $4,500 or $9,000 figure. Domain names themselves have sold for millions of dollars, and certainly the importance of a domain name to a website. You could imagine if Amazon, for example, lost Amazon.com, that the value of the domain names are so significant, and yet these competing claims to domain names are commonly resolved through an ADR, an alternative dispute resolution mechanism, and it is conducted, by the way, entirely these days online through the filing of papers, if you will, or as Alessandro was saying, PDFs submitted online along with evidence. And while there's not a jury in the UDRP system as there is in the TWiL system that Alessandro seems to be setting up, there is still a trier of fact and law or policy, if you will, that is a panelist who is assigned to review the complaint and the response and any other documents that may be submitted by the parties and issue a decision as to who gets the domain name. I don't mean to go on and on about it. It's something I feel strongly about because it's a large part of my legal practice. But I mention it simply as an example of what I think is a very successful alternative dispute system that did not exist too many years ago and has become the dominant way of resolving one particular type of dispute, and it's conducted entirely remotely, just as the system that Alessandro was speaking of. So I think under the right circumstances, a system like this, even if it's not this one in particular, has an opportunity to fill a need.
All right, so Doug, I was going to ask you to bring us up to speed about .XXX.
Yes, the long and interesting history of .XXX is going into the next stage, which seems to be live very soon, thanks to a vote by ICANN, the Internet Corporation for Assigned Names and Numbers. The board has approved the creation of the .XXX domain name, which will be used exclusively for porn or adult sites, and it is a fascinating history there. But I think really right now, well, a couple things. One, to continue the segue from the topic about alternative dispute resolution, it's interesting that one of the, I think, rather uncontested issues in the whole .XXX history is that disputes, or some of the disputes going forward, will actually be resolved by this same UDRP process that I mentioned just a minute ago. But what's more interesting is how this process will actually play out now that registrations will actually be functioning and domain names at .XXX will be live in the near future. This is something that will sort of be a bit of a precursor to a much larger expansion of the top-level domain name system that ICANN has been embarking on for some time. The .XXX is not in the same basket, if you will, as the expansion of the top-level domains that we're about to see, but simply the fact that we are going to see a new top-level domain added, a new generic top-level domain name added, which we've not seen for quite a few years now, will be very interesting to follow that. It is what's being called a sponsored top-level domain. That is, you must be in the adult industry to register a domain name in the .xxx, I believe. But regardless, the trademark issues that have dominated the entire domain name system will still be present. Now, from reading about what's been going on with .xxx through the years and in recent weeks, you would think that nobody in the world except the registry operator is in favor of a .xxx, because there are those in the adult entertainment industry who have said, well, we don't need a new top-level domain to operate our adult websites. Thank you very much. We're already operating them under .com and the other existing top-level domains. And so now you're just forcing us to defensively register our same brands in .xxx. That's sort of on the one hand. And on the other hand, there are those who might be painted as anti-pornography, who say that this is, creating an opportunity for even more, if that's possible, pornography and adult content on the internet. So it will be very interesting to see how it plays out. There are apparently quite a few number of what have been called pre-registrations of .xxx domain names. Whether it proves ultimately to be a successful top-level domain or not certainly remains to be seen, but it's one of the more interesting ones that we've ever had.
So in theory, folks who simply have a domain name that ends in X, say ame.xxx, would be prohibited from using this domain?
Is that the American Medical Association, or is that some other entity? I don't know what you're referring to there.
American Express, if they decided to get very cutting edge, could call each other AME.xxx.
Oh, okay. I understand that. I think I missed another critical part of the question yet again, thanks to our audio here. I think what's also fascinating is that this in no way, there's a bit of a misperception that the creation of a .xxx domain means that all adult content on the internet will be moving to the .xxx domain, and that in no way is true. There will be no prohibition on adult content in .com or .net or .org or any other top-level domains that currently allow this type of content, regardless of what you may think of it. So the only thing that we will know for sure, to answer your question, is that the websites ending in .xxx are likely to have adult content on them, but the opposite is far from true. That is, this is not the only place that you will find adult content online, or better or worse, whatever your perspective may be.
So it's just more adult content. Evan, that can't be a bad thing, can it?
Oh, I'm not going to answer that. It seems to me, and I know that this is some of the one of the objections that the adult industry, or at least members of the adult industry, has had, is that it may make it easier for internet service providers to, and I'll put it in air quotes, censor content, making it easier, to just establish bright line rules of content that they don't want running through the server because it originates at a .xxx domain. So I'm wondering if anybody else on the call has any similar concerns like that, because that does seem really legitimate given the protections that internet service providers have under Section 230. This is Section 230 of the Communications Decency Act. The broad latitude that service providers are given for their good faith efforts to screen content that they believe to be offensive. Another way of characterizing the issue is, is it now just going to be easier for internet service providers from a technological standpoint to screen content that it would not have been screening otherwise, and somehow we are not all better served by that? Does anybody else have any thoughts along those lines?
I would just say that, much of the adult content in the world, if not on the internet, depending upon your jurisdiction, is legal. And so there is a fine line, as the Supreme Court said a number of years ago. It's difficult to define pornography, or obscenity rather, but I know it when I see it. That's, a great quote. How useful it is obviously much more difficult to apply in practice. There are those who might think that the Sports Illustrated swimsuit issue that, we can see in the grocery store checkout line is content that should, appear only in a red light district, so to speak. But Evan, to your point, it's actually a fascinating question. I'm not aware of any law, at least in the United States, or anywhere, that requires an ISP to make content available to its customers. And so it's interesting to perhaps some ISPs might hold themselves out as a marketing benefit that we block or we allow content in .XXX. But I'm not aware of any law that actually requires an ISP to do so. That doesn't mean that there's not.
Well, it would actually, I think the law would actually be the contrary to that because of what Section 230 says. It's Section 230C2, and I hate to get too wonky on any of these kinds of discussions like this, but that's the less treated part of Section 230, where it says that an internet service provider can't be held liable for any of the good faith efforts it makes to screen content. So, and as I read, the law, it would be that an internet service provider can do whatever it wants to do as long as it's in good faith, to screen offensive content, since 1996, not, long before, the question of the .XXX domain. So the point I see is that, yes, indeed, let's just say you're an internet service provider in I don't know, Utah or something. We, make a hard and fast rule that no content coming from .XXX domain would make it through the system. So come pay a premium for our services because you're going to be getting less. I guess that's how it would pan out in the market.
Right.
Of course, what you may get then is only 99% of the porn online instead of 100%.
Right. Yeah, it'll take a few years for folks to get to it.
2 points occur to me. One is from Matt McCary in IRC, who says, so all the adult providers just aren't going to use .XXX, so they can avoid being filtered in this way. And I don't think it would have to be an all or nothing thing with the ISPs. It could be an option. You want to offer your services as broadly as possible. You want to capture families with kids who maybe want to have that option to check when they sign up for their service. Please filter XXX. Whether or not that's going to do a whole lot of good is the next question.
Yeah.
So, Alessandro, any thoughts on the internet ghetto?
Well, it seems to me like it might go the way of the .tel. A lot of noise and doesn't really get anywhere.
Right. Well, it'll be interesting to watch that one unfold. It's certainly been a long time discussed and in the coming. Also discussed for 7 years now, the Google Book Search Project, the scanning and indexing of the world's information of library materials, hit its latest snag lately when a judge in New York has decided to not approve the settlement that was put forth in the Authors Guild case. Evan, you want to unpack this one a little bit for us and tell us what we can expect next?
We could expect a number of different things. Google and the Authors Guild could continue to fight it out, and maybe we'll get a legal determination of this big question of fair use. Is it fair use for Google to scan all these books and make the snippets available? This is a copyright question. That's probably not going to happen. Judge Chin, who was the judge overseeing the Google book search case, rejected the settlement offer, or the settlement agreement that the parties had put together. It was this enormously complicated opinion, and an enormously complicated agreement, in his opinion, that he wrote rejecting it, even though it purported to just kind of treat the terms of the agreement only briefly, was still 48 pages long. And so there's a lot of stuff in there. He hinted at one point that the parties could, I think he used the word ameliorate the issues that he has concern about, and I'll address those in just a moment. He says that they could deal with those issues just by making the participation in the class of authors whose works are covered by the settlement agreement opt-in rather than opt-out. The main reason, there were a couple of reasons why the settlement agreement was not approved, why he didn't approve the settlement agreement, but instead found that it was not fair, reasonable, and adequate, was this question of orphan works. And as we know, orphan works are those works protected by copyright where the author just can't be found, so they exist out there. What Google got from this proposed settlement agreement, had it been approved, was essentially a monopoly over those orphan works, where it had the right to go ahead and publish those, scan them and publish those with impunity. And even if the author somehow revealed himself or herself and said, hey, I'm the owner of this copyright in this orphan work, Google would still have the right to do that, notwithstanding the author's objection. That was the big reason why Judge Chin found this settlement agreement not to be fair, reasonable, or adequate. And so there's where the opt-in part comes. If your membership in the class depends on you doing something affirmative to actually become the class, to put yourself within the class of authors whose works are covered by this, that makes it much more fair. And so it's probably what we'll see happen is more modification of the settlement agreement to kind of bring these sensibilities all under the tent of this litigation and this settlement agreement. So I think the smart money would be on just going back and doing a little bit of redlining on that 166-page settlement agreement.
That's a pretty big issue to redline, though, don't you think, Doug?
I think it's still a fascinating case. From a pure copyright perspective, it's easy to say now with the benefit of 7 years of litigation and documents behind us. But from a pure copyright perspective, it certainly seems that the copying an entire book without permission of the copyright owner, and using it in some way for commercial purposes is, if not the definition of copyright infringement, I'm not quite sure what is. Whether there's a defense of fair use, as Evan points out, given the nature of these as orphan works, is an issue that is certainly of concern, what to do about them. But ultimately, maybe an issue that's better addressed by the Congress than by the courts. Not that I see that happening anytime soon. We've already got patent reform going through the Congress. I don't know that our lawmakers are interested in mulling over too much more intellectual property, if you will. But the fact that the settlement was rejected does not seem like an outcome that would have been unpredictable a number of years ago. And, were it not Google leading this effort, probably we wouldn't have even gotten to this point.
Right. Well, I have our tip of the week and resource of the week to get to in just a moment. But now I'd like to thank our other sponsor for episode 104 of This Week in Law, and that's Squarespace.com. Squarespace is the fast and easy way to publish a high-quality website or blog, and it has the greatest UI. It is so easy to use. You can create and manage your entire site with this very intuitive drag-and-drop interface. It's optimized for both beginners and CSS experts. There are hundreds of design templates to choose from, and they're beautiful. They hire really good designers to generate these. And once you find one that you like, you can take it and customize it to your heart's content. This all-inclusive service includes several modules to build your website. There's a blog module that includes import and export support for WordPress, Blogger, Movable Type, and TypePad. This means data portability too. Once your data is in there, you can always take it out of Squarespace and go somewhere else. But I'm not sure why you would, because Squarespace offers so many great services and ironclad hosting that it is virtually impossible to bring down, because they distribute all of their hosting needs. If your site is getting slammed because someone has linked to you, you don't have to worry about your site being reliable and available. There's a form builder, there's Flickr photo display, there is a Twitter widget that lets you display tweets in your own website, which is customizable so you can have it look just how you want it. There are Google Maps and more. There are wonderful stats and search engine optimization features that are just built right in. There's permission access handling, the cloud architecture that I spoke about for speed and site stability, and an iPhone and iPad app that let you update your site on the go and monitor your comments and your stats and everything else you might need to do. Squarespace is for all of your website needs. You can build it, host it, and update it anytime. And you get a free 14-day trial when you go to squarespace.com. Sign up for a free account. There's no credit card needed. Just try it out and build your own wonderful Squarespace site. That's squarespace.com. Thank you so much for your support. So before I get to our tip and resource, I wanted to show something that Evan had sent me a couple of weeks ago that is just so funny. We were talking on one of the shows about great mashups. And Evan, give us the context on this. This is a Lionel Richie mashup as a I'm lost sign. And I think Burke can show it for us.
Yeah, these are great. I love these little things. And I forget what we were talking about, something a couple weeks ago as an example of remix culture. I mean, that's how that's the notion that I thought of when I saw this. What it is, it's a there it is. It's on the screen now, but for those just listening, it's it's in the genre of a what do they call them? Handbills, that a single piece of paper that you staple to the telephone pole, saying, this is, I've lost my cat or whatever. But it's a picture of Lionel Richie looking all suave, circa 1982, wouldn't you say? And
yes.
At the top of the page is hello, the question, and then underneath his picture, is it me you're looking for? Of course, invoking the lyrics from his number one hit. Of that name, right? It's called Hello. And then down at the bottom is all the lyrics of the song in the little pull tabs. You know how you can just cut the paper a little bit as if, in the traditional format, you take the phone number to call, and it's all of these little, each line of the song. I can see it in your eyes. Why don't you sing it, Denise? Can you
I don't know that I can.
I know that you've rapped before on the show, so I didn't know if you wanted.
Yeah, I don't know if I can channel Lionel just now. I do remember what we were talking about, though. It was R2-D2 hawking pizzas on
that's
a little
right.
sign. Yes,
yeah.
In Brazil, I believe. And we also talked
And so you
recently,
brought this up today, of course, because of the copyright infringement issues that it raised for reproducing the lyrics without permission of the copyright owner, of course.
Right.
Absolutely, yes. And we also talked recently about Exit Through the Gift Shop, the Oscar-nominated, and I don't know if it won, but excellent film about street art and culture, which is very heavily reliant on in a legal gray area, as one of the artists in the film.
Yes, and
put it himself.
And Sheen Family Circus is what I was thinking about.
Yes.
Also, remember the Charlie Sheen lyrics underneath the Family Circus cartoon panel. So here we are getting all excited about this stuff. But what it does is it's a nice little exemplar of a mashup of coming from a number of different places, and it's elegant in its simplicity. The way that that's done here, and it would just really be a shame if the rights holders here, which would be the record company. At least three different rights holders implicated by this. The record company, I guess it would be maybe not the record company because it's not a sound recording, but the publisher of the music, and then Lionel Richie himself, for his right of publicity, to the extent that would be invoked don't pick at me. It's not a commercial purpose. But in any event, the point I'm trying to make is it would be sad if expression like this were cut out or somehow quieted because of those interests, because of the wonderful entertainment value it has, and it gives us something to finish strong on the show here today.
Yes, exactly. And as our resource of the week, I want to point us to something by Dan Rainey at his blog. It's in our discussion points at delicious.com/thisweekinlaw/104. He attended a session at the Berkman Center for Internet and Society at Harvard on crowdsourced online dispute resolution. And he did this in September 2009 and live blogged, or very shortly thereafter blogged, his notes. So it's a great follow-on to our examination of TWiL and some thoughts about approaches to crowdsourcing and dispute resolution. So if you're more interested in those topics, go check out Mr. Rainey's entry. And our tip of the week is via Mashable, and they tell us with a bunch of statistics that piracy is now dead, or at any rate, on serious decline. And this was a post this week talking about the status of piracy. And I guess we're back to costs again, right? Because the reason that piracy has died is because the alternatives to piracy have become so successful. So it's a great post about the infiltration and current state of piracy in the United States, and I wanted to toss it out to you guys before we sign off today. Do you think that the costs of getting things legally have finally come down to the point where we can just say bye-bye to piracy? What do you think, Doug?
Oh, I don't think we'll ever say bye-bye to piracy, but it certainly is encouraging to know that it's a lot easier today and to obtain copyrighted content legally than it was just a number of years ago. And so I think that's good for everybody. It's good for the intellectual property owners. It's good for the intellectual property consumers. And it's great to hear that it's actually having a bit of an impact, whether the impact will be significant and how it will apply to other industries other than just the music industry is something we should all watch out for.
Well, one thing I think is interesting is you could look at this in two ways, right? That either all of the crackdown efforts have so scared people that piracy is such a now very dark net activity that people are just paranoid and don't do it. They don't want to be on the wrong end of one of these huge suits by the movie or music industries. Or you could look at it as the alternatives have just become so good, or, you know, probably the truth lies somewhere in between. But there was a great discussion on, I'm not sure if it was this week's Frame Rate with Brian Brushwood and Tom Merritt, of Brian talking about how he used to be an avid, you know, self-professed game pirate, but because of how well Steam works, and you can just, you know, you've gotten to that point with video gaming, at least in the PC arena, that you can have all of your games at your fingertips anytime on any device. And that's really, you know, all anybody wants with content. I'm thinking that with Steam, per Brian Brushwood on his show, Frame Rate, piracy in the gaming world has just become irrelevant because nobody needs to do it anymore. Do you think that we will get to that point with books and movies and television and music? Wow. Burke, can you hear me?
I can hear you.
I can hear you.
Everybody just decided not to answer.
Aha.
Well, I'll jump in then with something to say.
Please do. This is the greatest. This is my funnest end of a show ever.
No, I still don't think piracy is going to go away. I don't care how easy it is to legally purchase a book or a TV show or a movie or music, so long as there is a way to obtain it illegally, that will still occur, just like there is traditional shoplifting these days. So I don't think it will ever go away, but again, I think it's highly encouraging to know that you can hold a tablet device in your hand and without leaving your chair, you can purchase a book legally and have it in 60 seconds. I think that's great. So this is an area where technology and the law will continue to compete. It will still be illegal to make copies of content that you don't have the right to do so. But it's great to know that it's a lot easier to obtain all of that content legally.
Right. Evan, are you with us? And
yes,
do you have any
I'm
thoughts
here.
on the piracy issue?
Yeah, I mean, there has to be something up with these stats in the article. I mean, it's got to be something with the tracking, with more stuff that can't be tracked. With BitTorrent. I mean, it's if you look at, if you're reading about all the BitTorrent lawsuits that are going on, both over porn here in the Northern District of Illinois and in other places, and the U.S. copyright group litigation in Washington D.C. I mean, it's a little bit more difficult technologically to track, BitTorrent users and all that stuff. So, there's got to be something with those stats. And then, if that's not it, then it's just because the RIAA scared everybody off. Isn't it kind of interesting to see, they declared the end of their litigation war against individual P2P users in October of 2008, and so it trickled off a little bit out of there off of that. So I guess now that war declined, they realized there was no need to do it, and so people just stopped pirating music. I don't think that's the case. So I imagine there's a little bit of a statistical anomaly here on reporting that is aided to a lesser extent by the availability of legitimate content for purchase, licensed content for purpose. It's a combination of those two factors.
Right. Alessandro, what do you think? Piracy, alive, dead?
As a business person, I think piracy is fundamental to the evolution of the business market. If there hadn't been all the issues around music piracy, there wouldn't be iTunes. We wouldn't be discussing iTunes antitrust cases. Same thing for the movie industry or the book industry. It's more a reflection of products or services that people actually want and are willing to consume in large quantities, and consequently make it an issue that will then actually make the industry or certain industries move in a certain direction. So I have no problems with piracy, and I hope it still stays around for a long time.
Wow, that's a good perspective. I don't think we've ever heard voiced on TWiL quite that way, that piracy might be so valuable to the economic ecosystem that it should actually be fostered, perhaps, in some kind of policy way.
It's good for the lawyers. Do you still mean it if it benefits lawyers? Because we get to sue people.
That's all right.
true.
You guys will sue people anyway.
It's good for Alessandro, too, because people will go to TWiL to resolve their issues.
Well, what was that? Napster that existed, that was started before? That changed the whole industry, no?
It did. Continues to this day.
Right. So
All right,
there's a lot
folks.
to talk
Seems like
about
a
on
good
This
thing,
Week in
right?
Law.
I think that'll do her for this week. I really appreciate you all being here. And Alessandro, it's been a real pleasure to learn more about your business and get your insights today. Where can folks find you other than at TWiL.org?
That's it. Just there
That's
for now.
it? Just there.
Yeah.
Okay. And
We're
TWiL
working
is
on something else, but it's going to come out later.
Okay. TWiL is on Twitter, too, if you'd like to follow them there. They're TWiL on Twitter. So it's been a real pleasure and great meeting you.
It's been a pleasure for me as well. Thank you very much for having me.
And Doug, wonderful to have you back.
Thanks, Denise. Happy to be back.
And continue growing your online media empire over there at gigalaw.com.
Thank you for calling it an empire, I think, again.
No, it is just wonderful. You have a real knack for pulling out what's important and vibrant in the very already vibrant world of legal technology news. And I really value your skills as a curator of the things that I read online and as a commentator today on our show. So thanks so much for joining us.
Thank you.
And Evan, I always value your comments and skills. Thanks so much for being with us again today.
Thank you very much. I value the opportunity to be on the show. It's always a great time. You know, what a great way to stay on top of things. You know, preparing for these conversations that we have. It's really fun. And I said this last time Doug was on the show. You know, gigalaw.com truly is a classic when it comes to the kind of thing that it is. You know, a place where content is being selected and presented on a topic like this. He was doing curation a whole decade before people even called it curation when it comes to picking out the legal issues that affect the internet and vice versa. So it's great to talk with you, Doug. Always a pleasure. Good time.
Great.
Right.
Thanks, Evan, and for your work as well.
Thank you. And I think I have taglines for both of your businesses as the result of today's show. Webby and IRC told Alessandro that TWiL could be called the International Online Judge Judy. So there you go, Alessandro.
Yeah, okay.
We expect to see that up on the site shortly. And for you, Doug, you could just call Gigalaw, hey, we're even older than the Google Books case.
I like it.
So that's it, folks, for This Week in Law, episode 104. Join us again next week at live.twit.tv, 11 Pacific Time, 1800 UTC. We'll see you then. Bye-bye.